Good morning. I'm Gary DeWaal, and this is Bridging the Weeks for February 4th through 15th, and today is February 19th, 2019. I hope you had a good 2 weeks. Last week, the Securities Exchange Commission obtained a reversal of a November 28th decision by a federal court in California that denied it a preliminary injunction against the issuer of digital tokens that the SEC claimed was involved in a fraudulent and unlawful securities offering. The court agreed after reconsideration that the challenge conduct satisfied the criteria of a security offering and there was a reasonable likelihood of new unlawful activity if the defendants were not formally enjoined, at least preliminarily. Meanwhile, a well-known Canada-based issuer of digital tokens is fighting a threatened SEC enforcement action that might also claim it engaged in an unlawful securities offering over its distribution of purported virtual currency or utility tokens in the U.S. Separately, divisions of the Commodity Futures Trading Commission issued for the first time a summary of their examination priorities for this year. The days in the Northern Hemisphere are beginning noticeably to get longer. So I can get outside to enjoy some sunshine. Let's get started. A federal court in California that in November 2018 denied the SEC a preliminary injunction against defendants it accused of engaging in a fraudulent and unlawful offer and sale of securities in connection with a new crypto asset reversed course and granted the preliminary injunction last week. The defendants in this matter are Blockfest LLC and its chairman and founder, Reginald Buddy Ringgold III, aka Rasul Abdulrahim L. The court ruled that the defendants' promotion of BLV tokens on their website constituted the unlawful offer of unregistered securities. The court grounded its decision on the application of the three-pronged indicia of an investment contract, a type of security articulated by the U.S. Supreme Court in its 1946 decision SEC v. W.J. Howie, an investment of money in a common enterprise with an expectation of profits based solely on the efforts of others. The court held that the defendant's use of a website to solicit persons to provide digital currencies for BLV tokens satisfied the investment of money prong of Howie, while the website's indication that funds raised would be pooled and profits shared satisfied Howie's common enterprise and expectation of profits requirements. Previously, the court declined to find the SEC had made a prima facie case of past violations of security law because there were disputed facts regarding what was promised to actual BLV purchasers. However, in reconsidering the SEC's request for a preliminary injunction, the court accepted the SEC's alternative argument that, standing alone, solicitation on Blockfest's website constituted an offer on unregistered securities because solely an unlawful offer, without regard to sales, was sufficient to demonstrate a securities law violation. Additionally, the court said that, absent a preliminary injunction, there was a quote-unquote reasonable likelihood of a future violation by defendants. In its earlier denial of a preliminary injunction, the court concluded that a reoccurrence of any law violation was unlikely because of the involvement of outside counsel. However, in light of defendants' reference to a fictitious government agency on their website to promote their initial coin offering of BLVs as safe, and the withdrawal of defendants' counsel with no substitute counsel named, the court had no confidence that another violation would not reoccur. This is an important ratification of the SEC's view of when the offering of a digital asset may constitute a security. However, keep your eye on another lurking possible SEC enforcement action. Kick Interactive Inc., a widely used social media messaging company headquartered in Waterloo, Canada, may be soon named in an SEC enforcement action related to its distribution of so-called kin token to U.S. persons. The SEC claims these were likely security offerings, while Kick claims they were offerings of a digital currency or utility token. Kick has published the back and forth between the SEC and itself on its website, and the company is clearly set for a fight. I have details in the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. 3 divisions of the Commodity Futures Trading Commission issued their 2019 examination priorities. This marked the first time in its history the CFTC has issued such an advisory. The 3 divisions were the Division of Market Oversight, the Division of Swap Dealer and Intermediary Oversight, and the Division of Clearing and Risk. Frankly, there's not a lot of meat in staff's description of their 2019 priorities, so there's not a lot of guidance I can give. But some insight by the CFTC is better than no insight. Hopefully next year, there will be more. Finally, a former senior in-house counsel at Apple Inc., responsible for securities law compliance, including adherence with insider trading prohibitions, Gene Levoff, was charged criminally by the Department of Justice and civilly by the SEC with illegally trading on non-public information regarding Apple's financial performance. In both actions filed in a federal court in New Jersey, Mr. Levoff was alleged at various times between February 2011 and April 2016 to have purchased or sold shares of Apple stock based on his knowledge of financial results that were not yet publicly announced. As a result, he realized profits of $227,000 US and avoided losses of $370,000 US, it is alleged. This is a stunning matter to read about and very sad if the allegations made by the Department of Justice and SEC are proven true. Watchdogs must adhere to higher standards of professionalism and ethics to help enforce a compliance culture, not break laws, let alone violate common sense. Importantly, prohibitions against insider trading should no longer be just a concern for persons involved in the securities industry. Post-adoption of the Dodd-Frank Wall Street Reform and Consumer Protection Act in 2010, it's not just the Department of Justice and SEC that prosecute allegations of insider trading, but also the CFTC. I have more on the article version of Bridging the Week at www.bridgingtheweek.com. Again, check it out. Well, that's it for this week's edition of Bridging the Weeks. As always, there's more information in each article and more articles on the article version of Bridging the Weeks on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.